Okay, so our group will talk about forensic linguistics and language in the law. So first one, what is forensic linguistics? As the term offer you, forensic is something related to the scientific methods that involving solving crimes and investigation. So forensic linguistics is the study of language in the legal and investigative settings. Now we have three sub-areas. The first one is in investigative forensic linguistics. The second one is the study of written language of law. And the last one is the study of spoken language in the legal process. So now I will just introduce to you the first part, investigative forensic linguistics. In this area, people will try to apply the knowledge of linguistics into the investigation to provide advice, opinion, or even evidence. And one of the most famous methodology in this area is comparative authorship analysis, which stems from the cognitive theory of ideology. The theory concerned with the word choice, word frequency, the spelling of words, or even the complexity of grammar or the use of punctuation. So in the writing. So the basic idea behind this is to compare two writing to see whether this writing is composed by one person or composed by two different individuals. So this is an example for you to make it clearer. So now this is the case of Jenny Nicole, a teenager in the UK, and she disappeared. So why in the period of 9 to 14 days after her disappearance, she still sent messages to her friend. And the police doubt that whether these messages were sent in the period that she was disappeared isn't from her. So they sent the messages when she disappeared and the previous messages of her to the forensic linguists to see, to analyze the text, to see whether these messages are really from Jenny. So the forensic linguists will try to analyze the messages for consistencies or the distinction between them. So for example, you can see in the text, Jenny used number two for the word two, while Jenny's messages when she disappeared used two, but with space. Jenny has the habit of using see you, while Jenny's messages when she disappeared use see ya. And Jenny have the habit of using my and myself, while the undisputed message of her use me and myself. So the police conclude that these messages is not from Jenny, it's from the suspect. And as you can see, the characteristic of using me and myself is the characteristic of the Yorkshire variety, which reveals something about the identity of the murderer, which at the end turned out to be her boyfriend who comes from this region. So you basically understand what is investigative forensic linguistics is about. Now we move on to the next part, which is written legal language. So as you can see, that legal documents is really hard to understand and hard to read because they have two main features, which are impersonal and the contextualization. So people have the tendency to move toward the plain language drafting strategy to make the legal documents easier for normal people like us to read. So cohort in 2011 compared to insurance documents in 1963 and 2008, and he concluded that there is significant shift in the research as they become more personal style, and they include the introductions and the number section to provide an overview for the reader. However, there are some unchanged points, such as syntactics and lexical complexity, because, the legalese must be accurate and precise, so we cannot over easyfy it. But we don't. We need to understand the legal documents, because we have to understand our right, then we have no right, right? So we need to educate ourselves to understand the legal language. So now, if we want to understand the legal concept and the legal writing, we need to involve many competence, such as textual competence, discursive competence, the competence that involve the ability of relate the relevant facts, the real situation out there with the concept that they mentioned in the paper, and the generic competence and social competence. So these are the competence that the teacher might want to take into consideration when he or she teach the student from the law university in legal writing and understand the legal writing. So the next part, a communication in the legal process. My friend Song will talk about it.
Okay, so Wun help me to with the slides. Okay, so following the two first areas that Wun just mentioned to us, the last area will be communications in legal process. And as you may have all know, that communication is at the heart of resolving all the cases concerning law, so that we have to make sure that the interaction, especially spoken interaction, need to be investigative carefully, and also not to mention the written one. And sometimes we have to come at the convergence of those two. For example, when the jurors want to give instructions, so they cannot just read out loud their documents, because this contain a lot of technical terms and complicated structure, so that we have to simplify this to make sure that the listeners or the hearer can understand. So or another example would be the cautions from the police. So if the police don't explain it in the language that the hearers can understand, then we cannot ensure the mutual understanding. So the study of communication will have to make both the professionals and the general public become more mindful of the legal procedures, because that it is obvious that the professionals or people working in the law department have to be exposed to the procedures. How about the public? We don't know when or how, or maybe someday we may find ourselves in a situation that we have to use our language competence as well as the discursive competence that Wun just mentioned above, to protect and defend ourselves effectively in police interviewing as well as in the courtroom. And the last one, of course, we will examine some application for teaching English, especially general English and ESP, mean English for specific purposes, and also citizenship education as well. So in this area, there are two main concerns, which are police interviewing discourse and also courtroom discourse. So I will address the first one. So that over the past decade, so there was a shift toward a more like information elicitation and search for the truth approach instead of confession-seeking objective. What I mean here is that the interviewer now serves as a person who is looking for the truth and not the prosecutor one, who's usually intimidates the interviewees. So all in all, it means that we become more and more concerned about the stance of not just interviewer, but also interviewees. That is why we have generally three approaches in the peace framework. So this framework was introduced in the early 19th century, and it was used with 5 stages. So here, look at the photo. as you can see that apart from the first stage and the last stage, which is preparation and planning and evaluation, the three middle stage subsequent ones, they are closely related to the interviewees. So as the second stage, so the interviewer needs to engage and build a rapport with the interviewee and explain the situation. And in the account one, he or she will look for an open account or recollections of events from the interviewees and may challenge them using some conflicting evidence from their recollection. And in the closure stage, so they will summarize what has been said and give the interviewees a chance to add any extra information or any alteration, and before coming to the evaluation stage. So as you may see that the majority of time in interviewing focus on the interviewee. So that's why the three approaches from the PEACE model here also, like they are classified depending on the types of interviewees. So the first group that we examine here is the cooperative witnesses or victims. So generally they are willing to disclose any information that they know so that it's easy to just try to build the trust between the interviewer and the interviewee and try to help them recall what happens on the days by using like open-ended questions and some questions to ask with the context. However, on the other hand, the second group of interviewees, which are reluctant, I would say, uncooperative witnesses or victims, generally they do not believe in the police force for some reason, so that it's not easy for them to just present or just review what they remember from the events. So that in this situation, the interviewer needs to explain very carefully as well as listen actively and use like suitable question techniques to make sure that they can make the interviewee disclose information readily. And you know that just like what I mentioned in the model in the previous slide, as you can see that the last one is for the suspects. So you can see a striking difference here is the challenge part. So unlike the two previous groups, the last one, the police may have some evidence that's run against the interviewees. That's why they may use some clarification strategies and some conflicting evidence to challenge the suspects to make sure that they will cut through the denials and get to quick confessions. And of course, you know, the change also bring about the consideration for a special group, which is the vulnerable group. So these are what we can call like people who are easily psychologically affected or not in a stable, like mental stable state. So these can be children, they can be harassment victims, and they can be like people with impairments of hearing or seeing. So in this case, we need to use regulated intermediaries. So these are the law firms, or I say the organization which advocate the human rights. So by making use of these organizations or companies, we make sure that the rights of the interviewees are ensured, and then there will be easier communication with them. And the second area in the communication would be the courtroom discourse. So as you all know, in the courtroom, like the witnesses are of paramount importance because they will testify what happened on the dates in the cases. So depending on the purpose of the jurors, so we may have three types. The first one is examination in chief with friendly counsel. So its purpose just to recall like what happened on the days. As for the second group, as you can see on the slide, then they want to discredit the testimonies of the witnesses because the evidence is not consistent, and they want to challenge this. And the last one, if the witnesses are not consistent, they're not reliable, so the court may call for a re-examination. So now, however, you know that I will mention some positive changes. So these changes are generally like direct to the vulnerable groups, like I mentioned before. So for children or adults, vulnerable adults, so they may have a friendlier environment, similar questions, and also like using intermediaries, just like I mentioned before. And also for the groups of people who suffer from harassment or rape victims. So in cross-examination, like the lawyers or the defense like cannot ask about any of previous sexual experience of the victims, not to cause some damage to their mental and psychological health. And the same case go to the rape victims. So in the court, if the defendant is I can say that the suspect, right? So they're standing across the victims and they cannot cross-examine them directly because that is unfair. This may cause some psychological effects on the victims. So you know that the problems with communication in the courtroom, we can classify them into three groups, addressing three different types of individuals. The first one is the lay people. These are the people that they are no experts in law and they don't have sufficient skill and knowledge. So whenever they have to present the evidence in the court, they may miss some turns in contribution, which is adverse to their stance. And also, you know that they have to recall, or they have to retell their narratives many times in the interviews and then in court, and these are also recorded. So if they don't know what to say and what they say are not consistent, these evidence will run against them in the courtroom, obviously. As for the jury, so you know that when they call for testimonies, so some of the witnesses will add their interpretation of the events into their testimonies. So it makes it really challenging for the juror to discern the fiction from the truth. And the last group are a really special one. That is the litigants in person. So these are the people that present themselves without the lawyer. So obviously, you can guess now that they don't have sufficient skills or knowledge to defend or present themselves in court. For example, in cross-examination, it is shown that the litigants in person usually use open-ended questions, and that is harmful to their stance. Instead, they should use closed-ended questions to urge for clarifications and confessions. Yeah, so that is the case. So as what we have mentioned, so these are the chapters in the book, right? They have demonstrate how forensic linguistics raise the awareness for legal professionals to help with effective communication. However, raising the awareness of the general public is equally important, especially as a part of the school curriculum or foreign language teaching program. What I mean here is general English and ESP courses. With what is said, so it is really important to support young learners and adults to develop their discursive competence apart from their general language competence. So here we have an example of how it is applied in teaching English. So the study case here used video conferencing sessions for law students at 3 different universities. So if they participate in the course, they can also join in a mock trial with different roles. It means that they can put themselves in the shoes of different perspectives, like the witness, like the defendants, like the jury, litigants in person. So by working with the realistic tasks, which is closely related to their expertise and employability, they can also use English to communicate effectively and at the same time develop their discursive competence. So you know that like a shift toward like integrating discursive and professional practice into the curriculum will enable the student not just to communicate effectively, but also to pursue justice in case that they find themselves in such situation. And if you have both language and discursive competence, then you can ensure that the version of your story is heard. And then you can also find justice for yourself or your relatives. As in Vietnam, you know that it is really limited space for forensic linguistics, especially in Vietnamese high school, not to mention none, or maybe they will be taught like in Vietnamese, not English. However, in some bilingual school, so this program may be taken into consideration. But I think that the most like promising space or environment for forensic linguistics would be undergraduate, the student at university who major in law or police department. So understanding forensic linguistics and how to apply it in our like study research will provide a wide variety of options for English teacher. Yeah. So that's also bring me to the end of our presentation. Thanks for listening.